Hi guys, welcome back to Bad Talk with Ola. This is Mujela Olua and I'm super thrilled to be here once again. Today we want to talk about a very important matter because someone has asked that we talk about binding precedents. Binding precedents. I actually wanted to do a related video before, but somehow we forgot it by the progression of time. So let's talk about it in this video. Please like the video, leave comments in the comment section, and share the video far and wide. And if you have not subscribed to the channel, you've got to do so. Thank you and welcome to Bad Talk with Ola. What are binding precedents? Binding precedents are decisions, past decisions of the courts that must be followed in arriving at subsequent decisions. Essentially, the court has made a decision in the past, and now there's a similar case before it. It is expedient to just follow the decision and or the reasoning behind the decision in reaching this new current decision. So binding precedent is that principle that states or says that courts must follow decisions that have been made previously. Now there are a few things that are involved, and we're going to talk about them just right now. There's hierarchy of courts. We've talked about hierarchy on this channel. Please watch that video on hierarchy of courts. I will try to put it in the description box, the link to watch it. So hierarchy of courts is just the we can say the organogram, not necessarily, but the way that courts relate, how high one court is to or from the other. So in a binding precedent, in implementing or following a binding precedent, lower courts are mandated or can be compelled by decisions of superior courts. So if the High Court has made a decision in a matter, a magistrate court may be bound by that precedent. Same way, the High Court is bound by the decision of the Court of Appeal and the Supreme Court. The Court of Appeal is bound by the decision of the Supreme Court, and the Supreme Court is the final court, bound by its own decisions, except where it decides to, resile from that decision. So binding precedents is just the principle that makes life easy generally, is to say that there's no need to reinvent the wheel. If a superior court has decided this way and we have this similar matter before us, especially on all fours, or a particular issue that the court has decided in this way, in one case, we can bring the decision, we can apply the reasoning behind that decision in arriving at our own decision in this matter. Now, binding precedents have limits, and that is how we come to jurisdiction, which is another feature. We've talked about hierarchy now. Jurisdiction means that courts within the same jurisdiction, like national jurisdiction, for instance, are bound. They have binding precedents operate in the national jurisdiction. So for instance, Nigerian courts are bound by precedents of higher courts. Lower courts in Nigeria are bound by precedents of higher courts in Nigeria. But a United States court is not bound by a decision in a Nigerian court. Just like a Nigerian court is not bound by the decision of the United States courts. So in the past, Nigeria was bound by decisions from England, received English laws, and all of that, because we were a colony and we received our laws from England. But in modern day Nigerian jurisprudence, lower courts are bound by the decisions of the Supreme Court of Nigeria or superior courts in Nigeria. So that's the jurisdictional limit. Courts within the same national jurisdiction are bound by decisions of superior courts, but not by decisions of courts outside of a national jurisdiction. So that's jurisdiction. Then we talk about stare decisis. Stare decisis is a principle that means standing by the decision. Stare decisis, stand, decisive decision. So it's a Latin term. So it just means that a court is mandated or required to stand by an existing decision when reaching another decision that is similar to, with similar facts, that is on all fours. So there's no need to reinvent the way. I've said that, just shortly before now. So courts are bound to stand by a decision that applies to a new case where the facts are similar. There's no need to continue to deviate and continue to go on an academic expedition. Stare decisis is the foundation of binding precedents, and The rationale behind that is to ensure predictability and certainty, and to promote consistency, so that as a litigant, for instance, if you're going to court, you want to sue in a particular matter, you have a fair idea of what your outcome could be because it has been decided in so and so case. For instance, when we talked about Donahue and Stevenson on this channel, we talked about negligence, duty of care, and all of that. If for you bought, a bottle of soft drink too, and you have found something decomposing in it or something harmful in it, and you've suffered a damage, you can go to court on the authority or on the consideration of Donahue and Stevenson and say, litigant, that is what points you in the direction of the court, that, oh, the court has decided in this way, let me go and get justice too, just like as in this case. And as a lawyer, it helps you to advise your client properly and to weigh your options, weigh your client's options, and to be able to put a strong case together, because you know that when we are litigating as lawyers, we litigate on the strength of legal principles and judicial precedents. So that is what stare decisis does, and it generally gives the legal scenery or the legal playing field a certain clarity and consistency that helps people to appreciate what is really going on in the legal field, whether you're a layman, a law student, or a lawyer. Stare decisis also helps law students to understand and appreciate principles and areas of law faster, because that is what gives them real life examples, how the law has been applied in the times past, which will also provide a direction for how the law might be applied in the future. So that is what stare decisis means. Now, stare decisis can change. It is not static. It means that the court will not always decide the same way all the time and forever, but the court will likely decide the same way most times. The only deviations or the likely deviations would be where the society has evolved and such decisions or applications of law are no longer en vogue or are no longer compatible with natural justice, equity, and good conscience, or where it will be expedient or it will be more beneficial and more justiciable for the courts to decide otherwise. So that is so. It does not mean that the court will become a robot, that when you go to court, the court will just say, oh, as it was in A, B, and C, so it is in D. No. The court will still weigh the case, the facts, the peculiarity, and the argument, posed by the litigants and their counsel before it arrives at a decision. But essentially, stare decisis helps the court, the laymen, the litigants, the law students, and all stakeholders in the justice sector to appreciate law better and arrive at decisions faster. Now, that is all you need to know about binding precedents for the most part. Now, binding precedent is a component of a larger phenomenon called judicial precedent. Judicial precedent just means that cases that have been decided in the past. If a judgment is pronounced now, the next moment it has become a judicial precedent because it is now in the past. So judicial precedent can help to forecast the future of justice and the application of law. Now, binding precedents is a part of it because it is the precedents, the decisions that are binding on courts in arriving at future decisions. Not all decisions are binding. It depends on, it's a case-by-case weighing and decision making, but binding precedents form part of judicial precedents. Judicial precedents are generally decisions of courts in the past. Now, when they become binding in arriving at another or a current decision, they become binding precedents. Judicial precedents have a number of components as well, just as binding precedents has some features. And the components of judicial precedents are obiter dicta and ratio decidendi. These are Latin terms. Ratio decidendi just means the reason for the decision, the reasoning of the court in arriving at the decision in a judgment. So if you pick up a piece of judgment, the judgment of a court, for instance, if you pick up Musa Sadao and the state, if you pick up Garba University of Maiduguri, if you pick up Donahue and Stevenson, if you pick up Ida and Woodmansey, if you pick up Asari Dokubo or Dokubo Asari and the federal government of Nigeria, these are all cases we've discussed on this channel. If you pick up any of those cases, You would find in the judgment what is known as ratio decidendi, obiter dicta. You would also find the facts of the case. You also find a stare decisis if it applies. Those are the most important components of a judicial precedent: the facts of that particular case, the ratio decidendi, the obiter dicta, and the stare decisis if it applies. Now, let's take them one after the other. We've talked about stare decisis. So when you pick up a court judgment, what you would find, where the court is citing other judgments that have been made that apply to particular aspects of that current decision, the one you're reading, that's the stare decisis. So when, for instance, a court will say that, oh, in the case of so and so, the court decided so. If a court of appeal is arriving at a decision, for instance, then they say that, oh, in so and so case, the Supreme Court said so and so it is a given that this is the position of law. That's the stare decisis. They've cited a Supreme Court authority which is binding on them, a binding precedent. That's one. Then we have the ratio decidendi, the reason for the decision. That's the reasoning of the court. How did we arrive at this decision? It's the most important part of a judgment. What rule of law did the court apply? What considerations did the court make based on the facts before it and the argument posed by the counsel in arriving at what and the evidence that was presented, adduced, before the court arrived at the decision? That's the ratio decidendi. Ratio, reason for the decision, decidendi. Then we have the obiter dicta. Ratio decidendi is binding also. It has binding force. But we have obiter dicta, which is sayings by the way. Dicta is saying in Latin, obiter is by the way, around. So sayings by the way, those ones are not binding, but they are also part of a judicial precedent. So when you pick up a court judgment, you find the facts of the case, which is what really led to that litigation, things that happened in real time before our parties came to court. Then you would find stare decisis, judgments, binding precedents that apply in that case. You find ratio decidendi, the reasoning of the court in this particular matter, and then you would find obiter dicta. Those are sayings by the way. They are usually witty, they are wise, they may give a hint, and they may just generally advise, but they are not binding. But it could be a consideration in another case. It could help to advise a lawyer on how to put together another case. It could provide some insight into why the court has moved that way in that particular case, for a student reading it, for a layman reading it. And it's generally educating and entertaining as well, because judges usually have a lot to say, especially in interesting cases. So if you pick up a court judgment, I dare you to pick up a court judgment today. You can just Google judicial precedents in Nigeria or decided cases in Nigeria to bring out at least one court judgment. Then you can read it and pick out these things: stare decisis, obiter dicta, reasoning for the decision, that's ratio decidendi, the facts of the case. So we've talked about two things. We talked about binding precedent first, then we talked about judicial precedent, which is the overarching phenomena, and binding precedents, which is just a part of it. I want you to look up these things. You can go back and watch videos of judicial precedents. We even have a playlist tagged judicial precedents where we talk about decided cases on this channel. Go to those videos and watch them and try to bring out these things that formulate what a judicial precedent is, and the things that formulate what a binding precedent is. That's all I have for you in this video. I will see you in my very next video. Don't forget to subscribe. Toodles.